Welcome to Rock Center Shorts. I'm Kristen Savell, Co-Executive Director at the Rock Center for Corporate Governance at Stanford. Today, we're going to talk about new subsection 18 to section 122 of the Delaware General Corporation Law, which I will refer to as subsection 18 going forward. Subsection 18 provides statutory authorization for stockholder agreements and was one of several amendments to the Delaware General Corporation Law that was proposed by the Council of the Corporation Law section of the Delaware State Bar Association on March 28, 2024, and signed into law by Delaware Governor John Carney on July 17, 2024. The amendments are effective as of August 1st, 2024, which happens to be the day we are recording this video. My guest today is Lauren Pringle, Editor-in-Chief of the Chancery Daily, which is a legal publication covering corporate and commercial law in the Delaware courts. Previously, Lauren was a litigator at Fish and Richardson. Welcome, Lauren.
Thanks for having me. It's so nice to be here.
Glad to have you. Before we dive into subsection 18, I think it would be helpful if you could explain what stockholder agreements are and when they are typically used.
Of course, yeah. So the backstory here is that stockholder agreements generally used to be between stockholders in the main. So they would deal with issues of voting, governance, but in that example of, stockholders, sort of intra-stockholder agreements, you could think about it as, then the agreements might include like tag-along or drag-along rights, other buy-sell agreements, but you also saw things like cooperation agreements that are used in the activist context being called stockholder agreements. So the point being that the term stockholder agreements is a very broad term that's ended up sweeping in all sorts of different types of agreements that really don't look very much like each other. So in the settlement context with an activist, you might see, it's truly just a strategic settlement agreement, but they would be called shareholder agreements or stockholder agreements. You would see things like, declassification of classified boards, right, to nominate folks for various committees or positions. But over time, these agreements seem to have morphed into what some people call new wave agreements, new wave stockholder agreements. And as far as I can tell, these are mainly used in like private equity and venture capital, where now we're talking about a contract between a single stockholder or perhaps a small group of stockholders and the corporation itself. So no more talking about the interest stockholder type of agreements, but again, historically, we've used the same term for all of these types of contracts. And so it's gotten a bit mushy. In the modern iteration, these new wave agreements, the corporation is the counterparty. So it's between a stockholder and the corporation. We'll talk later about how after subsection 18, we could even be talking about a prospective stockholder, not even an existing stockholder. So in any case, we've been using a lot of broad sweeping terms with very little nuance in our sort of historical use of this term. And I actually think that that's part of why everything that has played out with these DGCL amendments has been sort of a learning experience for people. Also, a lot of cross-talking between the sides because we were talking about a thing that actually has a sort of species of thing that has perhaps a lot of different subtypes inside of it.
Mm-hmm. Can you provide some background on what led the corporation law section of the Delaware State Bar Association to propose new subsection 18 and give us a brief overview of what the new subsection does?
Yeah, absolutely. So the main sort of catalyst, I think, is just that the Moelis decision came out on October 18th, 2023. This was West Palm Beach Firefighters Pension Fund versus Moelis and Company. It was about one of these new wave agreements where Ken Moelis was given certain pre-approval rights, certain, I think it was actually maybe ironically 18 different types of rights, maybe 17. Anyway, a whole host of various governance rights were at issue in the Moelis case. And just to step back a bit, when the decision came out, I think what happened is that it sort of fractured the world into two views. One where nothing was changing and one where everything was changing. And so the Mullis decision itself found that this new wave type of agreement, which was between Ken Mullis and the company, again, not an intra-stockholder agreement, not an activist settlement kind of cooperation agreement, but what we are now referring to as stockholder agreement, which is also called a new wave stockholder agreement. There was a world where people believed that this result was just wrong, the court just got it wrong, or the statute was so sort of antiquated or out of balance with the real world that amending the statute wouldn't cause any trouble because we would just be keeping the status quo. And then another group of people who saw this as, okay, the Mullis opinion comes out, it's just sort of reaffirming what we've always known, which is that Delaware is a board-centric state. We believe in board centricity. Under Section 141A, the board manages the corporation. The corporation has to be run by its board of directors. And what Section 122(18) does is it authorizes contracts going forward and retroactively that these contracts are now allowed explicitly to set forth certain types of provisions that may be included in contracts between a corporation and its current or prospective stockholders, even if those provisions are not set forth or referenced as facts ascertainable in the certificate of incorporation pursuant to 141A. That's a lot of legalese, but basically what it's saying is that things that previously, under one worldview, would have had to be included in the certificate of incorporation in the charter so that they were on file with the Delaware Department of State, so that they were publicly available, that these same types of rights could now be delegated or given to someone through a private side agreement, a contract, so that they would be sort of in the realm of contract law and less in the realm of corporate law, which for a lot of people seemed to have a lot of implications that we weren't really sure whether that was good or bad. Again, the proponents said, well, we just want to keep the status quo. Delaware is a great state to incorporate in. Everyone incorporates in Delaware, despite the rumblings of some billionaires that you might not have heard of. Delaware is the place to be in the corporate law sense, and we want to keep it that way. And so keeping the status quo is what we should do. But again, because you had this sort of fractured worldview where you had two groups of people thinking that this was either a massive change or it was no change at all, the debate around whether these amendments that were proposed should be passed, should be put into law became very controversial. And there was a lot of discussion, perhaps in an unusual way for the way that Delaware manages the Delaware General Corporation Law. There was a lot of public discussion about whether or not this was a good idea.
Mm-hmm. So as you noted, subsection 18 is proved controversial with private equity, venture capitalists, and transactional lawyers standing to benefit from the amendment, a number of corporate law professors opposing it, and even Vice Chancellor Travis Lasser questioning aspects of the amendment. You summarized some of the arguments that were raised in support of subsection 18. Can you identify some of the arguments that were raised in opposition?
Yeah, I think so. Again, the proponents were saying we need to show that Delaware is a responsive state. We need to show that we're responsive in modifying the DGCL when something seems very out of line. And all that we're doing here is just aligning with market practice. That was the proponent side. The opposite side was saying, look, Delaware is historically, the board-centric 141A model is sort of the gold standard of Delaware law. Section 141A says the businesses and affairs of the corporation in Delaware shall be managed by or under the direction of a board of directors. And when you authorize these side agreements, the opponent's position was that you are risking delegating authority that has historically been reserved for the board to other folks, and that the entire way that the Delaware corporation law works in the case law and in the statute is that it's sort of always relied on this fundamental premise that the board is in charge. And if you shift that through contract, through a side agreement, you're really sort of messing with a fundamental balance that has always been in place. And that gave a lot of people pause that we were making a more radical change in Delaware than perhaps it was being represented to be.
Some proponents of subsection 18 claim that the amendment creates more certainty in the law after the Moelis decision. Do you agree with that position?
I think that in a sense, yes, like there is certainty that you can enter. The language is incredibly broad. It's a grant of sort of unfettered rights, although there is still a provision that was insisted upon by the proponents that this did not sort of get rid of any fiduciary obligations on the part of the board or anyone who would enter into one of these contracts. There was a lot of debate about whether that was how that would play out. And I think that that's where the uncertainty comes in for me. With any new legislation, you're going to have questions. How is this applied? How are the courts going to read it? How is it going to be gamed in the marketplace? Like what very creative transactional planner is going to come up with some new wave agreements that are sort of like, oh, now that this is all statutorily authorized, what can we do with this? How can we play with this? If we start seeing new wave agreements, then the sort of barn door has been left all the way open, and it's really hard to see how we can meaningfully cabin the potential scope of these agreements. Again, however, you have the proponents saying, we've been doing this for years, nothing bad has happened, Delaware law has not collapsed. And again, with that fracture of worldviews where one side is saying nothing is changing and the other side is saying everything is changing, there was a lot of crosstalk about who was right. And I think that's where the uncertainty arises. The certainty came in the fact that the existing agreements, there were tens of thousands, maybe it's unclear to me exactly, but various numbers were floated around during this process of how many of these agreements already existed out in the world. The certainty is now those investors know that they're safe. They have the rights that they thought that they had bargained for. So that did provide certainty, but a whole other realm of uncertainty is now sort of raised where, are these stockholder agreements going to become more prevalent? Are they going to more frequently include governance rights? How crazy of a sort of situation can you think of in the usual ordinary course business? We might not see much change, but in my position, I'm always seeing the things that are the outliers, the things that get to litigation, the things that come in front of the courts. And my brain is always just sort of chewing away on how is someone going to take this to the next level? And that's where the concern and the uncertainty comes in for me now that the statutory authorization is so broad. I mean, one specific question, for example, that I think there's a lot of uncertainty about is how are the courts going to handle a request for specific performance to enforce one of these agreements if it does have incredibly broad rights and it effectively is an agreement between the company and someone who is now basically a controller? Are they going to grant specific performance of the agreement if that seems in contradiction to what fiduciary duty would require? There's a whole host of sort of very complicated legal issues that I think we're not going to know the answer to sort of how it's going to play out until it plays out in court.
I want to talk through some of the potential impacts of new subsection 18 on directors and officers and on corporate governance more broadly. So as an initial matter, how do you think subsection 18 will impact the role of the board?
Yeah, it's interesting. I mean, I think the fear is that it's going to weaken the role of the board. Now, of course, if you don't enter into one of these agreements, then the change in the statute itself isn't going to sort of do anything to you, except that it could potentially make you more vulnerable to activists who come in. And again, in one world view, previously, when activists would come in and demand certain things in a cooperation agreement or a settlement agreement, you could say, sorry, we can't give you those things because the statute doesn't allow it, right? We can't give you pre-approval rights or some sort of, any number of things that activists might want to demand. You could just kind of lay back on the statute and say, that we can't do that. But again, in the world where that wasn't how it was going, and everyone in the world where sort of the history, the canon is that everyone knew that these agreements were okay and that Mullis changed that, then, well, I don't know if there'll be any change, because if everyone already thought this was all valid and possible, then perhaps they've already sort of pushed the outer reaches of this universe. It's, again, unclear. And I think that, now things that boards typically do and have done in the past is certainly now in the potential provenance of one of these agreements. Hiring and firing a CEO, entering or terminating M&A agreements, granting stock options, issuing securities. And in that sense, like, once you give away those bundles of rights, what is left for the board to do other than enforce a contract that it entered into about how it would decide on those issues?
Do you see some of this uncertainty playing out primarily in the private company context or in the public company context as well?
Yeah, I think that's a good question. And I think that it seemed to me that in the course of this debate, most of the focus was on the private company context, because this is really where I think these agreements exist. This is where the big concern that people have about the non-public nature of them is really problematic, because in a public company, you have disclosure requirements from the SEC that will make these agreements, at least in the main, available in a public company context. In a private company context, there's no such demand for notice. Due diligence is going to become a bigger deal than it obviously already is in the private company investment context, because you really need to know before you can either meaningfully invest or sit on the board of a private company. Is there a stockholder agreement in place? Is it, how is my world already delineated or sort of designated such that I can only make decisions within some framework that's been set for me, and for the company? So there's a lot of new considerations, I think, particularly for private companies. For public companies, hopefully it's less of a shift, because they will be disclosed. Again, whether things are disclosed and whether they're comprehended or actually internalized by investors is another question. So just because it's footnoted in an SEC filing or referenced by incorporation somewhere or something, it's, again, there's a lot of questions about how much transparency there will be even in the public company context, but certainly in the private company context, that was one of the biggest concerns.
I want to pull on a thread that you raised in your response. How should directors think about subsection 18 and potential fiduciary obligations when considering whether to accept a new seat on the board of a Delaware corporation?
Yeah, I mean, it seems like a huge consideration to me now, because first of all, if there is an agreement in place, you have to know about it, right? I don't think you can meaningfully make the decision about whether to accept a seat on the board without knowing whether there's one of these agreements in place, because genuinely one of these agreements now has sort of there are no walls in this room, right? It's wide open. Everything that you could think that you were meant to do as a director in the past could already be delegated to someone else to decide, and your job as a director is now to rubber stamp effectively that person's decisions. Just to me, as a human who understands sort of the way negotiations work and the way that a directorship might optimally function, that seems suboptimal to me, to have your decisions already sort of made for you or be subject to veto rights by someone. So first thing to know is, like, is there an agreement, and what does it say, and what are its limitations? And also, I think, if there is an agreement, you also have to then think about, well, will there be more agreements, and sort of how is that process going to play out? Because the decision to enter into one of these agreements, which I think is just sort of more likely to come up if the company has already shown that it's sort of working in this framework where they are using these side agreements, well, that's a whole sort of talent set that I don't think we're necessarily factoring for when we're thinking about who makes a good director right now. I think that having to imagine all the various possible permutations of reality 5 years from now, 10 years from now, however long some of these agreements can sort of go on infinitely, but a lot of them will have practical sort of temporal sort of expirations or time limits on them, but they don't have to. And so when you're entering into one of these agreements, I think that's, if you're dealing with a company who is likely to or considering using one of these agreements, I think you really need to consider whether that's a decision that you want to have to make someday. Because it's a big one, and we can talk a little bit more about, you know, like what it actually means, but there's a whole, it opens a whole host of things that you would want to think about if you have one of these agreements in place and you're considering a board position, or if you're dealing with a company who is considering dealing, you know, having one. Any company in the PE space, any pre-IPO company, you know, it seems like a lot of private pre-IPO deals are getting done this way now. And so, you know, dual class sort of fell out of favor. And this is a new way to get the benefits of dual class without actually having, you know, to have a dual class. And
can you explain that a bit more?
Well, basically the types of rights that were given in dual class to preferred, or, you know, to whatever the superior class was, any of those rights can now be given through a side agreement, and it doesn't have to be disclosed in the charter. I mean, the charter now will tell you if you have blank check preferred or whatever. And so there is a way that some of these rights that could have been given via blank check preferred before, but it would be public, and it would be yeah, I mean, that's the real thing, right? There would be more visibility into it. In the private company context now, if this is not in the charter, there can simply be an agreement that isn't disclosed anywhere. You could pull a copy of the charter from the Delaware Secretary of State, and you would not know that this agreement existed. So whereas previously there was a bit more transparency about how everything was operating, now you can sort of achieve the same rights objectives, which some long-term investors may not think is in their best interest if they're considering whether to invest in a company. There's just sort of a broader range of due diligence that has to happen now to access actually what's going on in the company, and who has the real right to govern the company, who is getting a final say or a veto or some other kind of pre-approval right. It occurs to me like it's no longer as clear, and it requires someone to be much more diligent in how they suss out how the company is actually being managed.
The synopsis accompanying subsection 18 provides that, and I'm quoting now, new section 122.18 does not relieve any directors, officers, or stockholders of any fiduciary duties they owe to the corporation or its stockholders, including with respect to deciding to cause the corporation to enter into a contract with a stockholder or beneficial owner of the stock, and with respect to deciding whether to perform or cause the corporation to perform or to breach the contract. How do you see the interplay between the board's fiduciary and contractual obligations playing out in practice? Because it sounds like those obligations may conflict in certain circumstances.
Yeah, it's certainly the big question. And one of the things that sort of kept happening in the debate about this was there was a lot of talking past, both sides talking past each other, one saying fiduciary obligations still remain exactly intact, and the other side saying, but do they? Because honestly, we've never lived in a world where this was statutorily authorized to such a broad degree. So we don't really know what fiduciary duties look like in the context of a world where the statute says you can do this, right? It changes the landscape fundamentally in analyzing what duties are owed and how those duties look in real life, to have a statute now, as of like, as you mentioned today, saying that this is statutorily authorized. So I think that there's two sort of buckets of things to consider. One is on the front end, when you're entering and when you're in the position of potentially entering into one of these agreements, right? There was a lot of talk about how fiduciary obligations will fully apply at that moment. You will be subject to, But as I sort of alluded to before, it requires then that you, in order to suss out what fiduciary obligations you could be breaching at that point, I think you need to have a certain set of skills, or you need to hire the proper advisors to help you understand what you might be doing that's unintended consequentially in the future by entering into one of these agreements now. Because they allow you to delegate away the rights to certain traditionally board reserved functions, well, I don't know how you can actually give away those rights in a way that is in accordance with your duties to the company when you don't sort of know how those actors to whom you're delegating the rights might act in the future. There's obviously always some complexity of navigating those kind of questions, but this seems like a more direct concern, which is, if we're going to give away the right to X, Y, and Z to so-and-so, well, is that a good idea? Is that abiding by our fiduciary obligations?
Mhm.
How much do we have to know about that person and their plans and their past? And it just makes for all sorts of weird thought experiments. So I think that in entering into the agreements on the front end, there is a significant amount of risk, and the way to mitigate that risk is to get advisors to help you out, in the same way that you would in any other kind of conflicted transaction or any sort of major deal that you might be doing. You're going to want to get legal advice. You're going to want to get, even potentially form a special committee, employ whatever protections you can to insulate yourself from the decision you're about to make, which could be incredibly consequential and could bind other members of the board who don't even exist yet, right? It will bind future members of the board. So I think there's a lot of responsibility that you should take on there in being a loyal fiduciary. Back end sort of bucket is compliance with an agreement that already exists. And there's a lot of issues here that have not been sort of fully teased out legally, sort of when issues of efficient breach, issues of like, do we have to perform this contract if it turns out that it ends up being a really bad idea that we entered into it? Do we still have to perform under it? Do we still have to allow a person who is potentially doing something that wouldn't at that moment be something that I as a director would do? I think there's less risk there because Delaware is a contractarian state and we do respect private ordering, which is again one of the reasons why opponents were very opposed to this, because once you give something, the statute gives you the imprimatur of saying you can enter into these contracts. The contract itself is very likely to be honored by a Delaware court. There's sort of a lot of thinking about the future and the implications and the potential and your fiduciary obligations that has to be done in a compressed moment of time when you're entering into that agreement. And if that hasn't been done properly, or if the world just changes in such a way that it makes it difficult to keep the agreement, then that gives rise to a whole other set of concerns. Another thing on the front end to consider is, when are you engaging in a transaction that might functionally make the counterparty a controller of the company, or are you triggering a change in control of the company by effectively delegating away these rights? Do you trigger Revlon when you enter into an agreement that's considered a change of control transaction? There's just all sorts of, again, complexities that I don't think come with just entering into any other agreement or any sort of function of the board in its historical context was, at least in my opinion, sort of like limited to the time and space that it was in, right? The decision arises and it's like, okay, how do we manage this? Now you're obviously always forward thinking and such, but this is such these stockholder agreements allow people to grant rights that are sort of so perpetual and ongoing that they have a breadth that is, I think, kind of, at least for me, if I were a director, would be worrisome when I was considering whether or not to enter into one.
Do you have any advice for boards that are thinking about entering into a stockholder agreement in the wake of subsection 18?
Yeah, for sure. Use the protections that you know to use. Get your advisors on the record. Get your special committee together if it's a major deal that feels like a change in functional control. You need to have that, you need to have a lot of minds other than just yours thinking about the implications, the potential legal implications, the potential practical implications, the potential business implications. We either need to start having directors who have these skills innately, but also we need to employ lots of advisors to, help us think through, what is this going to mean for the company? Is this a good idea? And again, the best way to protect yourself is to have other people help you out with that sort of thinking process and really analyze it with lawyers and with advisors, to protect you from any personal liability. Just, do the same job that you are always doing, trying to be a loyal fiduciary. But I think here there's a weird sort of type of expertise that we're going to be demanding of people to sort of see the future, which is obviously not possible, but that we have to do a lot of creative thinking about, is this a good idea long-term? A lot of long-term thinking and sort of gaming out the possibilities of how these things could go.
And should boards be thinking about the circumstances under which they're adopting these types of agreements? Like, should it be on a clear day versus
Right.
when there's an activist that's looming?
Right. Yeah. I mean, absolutely. You would love to sort of get this all sorted out, like on a clear day, in the sense that you don't want to be. It depends, right, on what the activist situation is, but you want to have the time. Well, first of all, you don't want to be in a situation where you're very likely to be sort of up against a super creative transactional planner who is attempting to sort of get you on your heels, right? So I don't think that this is going to come up in the vast majority of companies or situations, but I do think that, to the extent that you can have a sense of what the company needs, I would personally, I can think of so many various situations where this might not be good blanket advice, but I think that no matter what kind of a day you're entering into one of these transactions on, you need to have, I hate recommending sort of more process and more special committees and more, just like, because it seems kind of like a cop-out. But I actually think that you really need more lawyers in the room now to look at all of the complexities of the situation that you're in and sort of say, is this a good idea or not? And again, I don't know, but I imagine that directors might not want to hear that they just need more legal advice. But I don't think that the landscape is sufficiently clear right now about how this is going to play out in the courts. I don't think I personally wouldn't feel safe. I personally, even in my position here, wouldn't feel safe entering into one of these agreements without legal advice from an advisor, even though I am a lawyer who studies these things for a living, because you just really want to have that advice of counsel.
Last question for you, Lauren. For companies that are wary of stockholder agreements, are there steps they can take now to restrict the use of these agreements?
I've been thinking about this a lot, and I have some weird creative sort of like funny thought experiments about it, but I think yes, technically yes, it's a requiring statute, not a permitting one. So it does allow for an opt-out. However, if the company wants to opt out, they have to do it through a charter amendment, because it has to, your charter has to then explicitly state that you're opting out of stockholder of section 122.18. Of course, no existing charter has that provision as of today, because 122.18 didn't exist, which is what I was talking about before, where the whole world before didn't exist in the context of having a statute that said what 122.18 does. So now we live in this new world where it does say what it says, and every charter is absent a provision that is an opt-out for these. So you'd have to actually get the vote required for a charter amendment, which is not something I think a lot of companies are going to want to do. But I think that, it's definitely possible. I think the sort of better course is, because that would also be a big a decision, right? To sort of, you would want the vote, you would want the requirements that are necessary to make a charter amendment. You want those in place because you wouldn't want to make a decision like that on your own. You wouldn't want to, as a board, say we're never going to enter into these agreements, because God forbid, then you find yourself needing to enter into one and you can't because you've tied your hands. But that's sort of the concern generally with these agreements, is that it's hard to know what's going to come up in the future. It's hard to make the decision about how someone should decide something in the future when you're sitting in the past without all the facts and circumstances available to you. So look, like I said before, Delaware is a contractarian state. Whether or not you could enter into a contract with someone to never enter into another stockholder agreement is actually something I've been musing about, like as a thought experiment. Like, could we enter into a stockholder agreement that says we will never enter into any other stockholder agreements? And the thing starts to sound pretty absurd as a thought experiment pretty quickly, but I think it shows something about the kind of insanity that can be given rise to here, where you can actually enter into an agreement that has such perpetuity and such impact for the company, when it's an agreement potentially between someone who isn't even yet a stockholder and the corporation. So there is a lot to think about. There is a lot that is enabled, I think, by the new subsection 18. And I think it dramatically changes the landscape for companies where it becomes an issue, where it comes up, right? For most companies, like I said, I don't think you're going to see some huge change in the way that your life is as a director. If you're just a normal operating, widely held, sort of in the ordinary course, I don't know that this is going to come up a lot. But when you hear the concept, or when someone floats the idea, or when it's mentioned, I think you really need to be like on a hair trigger listening for it, and make sure that you understand the implications, or the potential implications of what it could mean for the company and for you as a decision maker.
Great. A lot to be worked out in the coming years.
There is. I know it's never boring here.
Well, thanks so much for joining us today, Lauren. It was wonderful to have you.
So nice.
Thanks to everyone in the
Thank you.
audience for tuning in. We will see you next time.